This is part of our special webinar series, and today we're going to talk about farm succession planning. For those of you not so familiar with 10,000 Girl, we are a small not-for-profit organisation that exists to improve the financial well-being of Australian women, especially with a focus around reaching women in rural and regional Australia. And we run workshops and webinars and different online programs to equip people with some ideas and some confidence and some tools and some connections to power forward in their financial journeys. So our goal was to help 10,000 women. We've actually surpassed that, but we are just keeping on, keeping on. So the succession planning process. I'm sure that there are women from all different farming enterprises across Australia involved in the webinar today, and I'm sure everyone has an appreciation of succession plan not always being a straightforward task. And so today we're going to talk about ways to open communication and to start conversations and to start exploring and aligning goals and working together. We're going to talk about the importance of maintaining financial and legal sort of transparency through the process. And then Catherine will take us through some of the legalities, the importance of having an up-to-date will, powers of attorney, setting up trust structures, etc. And we will be able to answer questions along the way. If we don't get to your question, then please, we will certainly be sending through this recording and some other resources, and we will try and cover it in those follow-up resources. So there's been some great questions actually that have been sent through, and we'll cover these at the end, but this is a bit of food for thought. So one woman emailed with a really interesting topic interest and wanting to know about how to deal with the emotional aspects of the people's wants and feelings through the process, particularly the older generation and the men. Someone else said, I'm interested in this as I feel like getting everyone together and on board is our challenge. This is a really common thing we hear about in the workshops, like just simply starting the communication process and getting everyone on board. And then there were, I'm sure there's a few questions that are more specific to your personal circumstance. So someone shared that they're currently going through succession, and a letter arrived last night detailing the proposed split between 4 farming sons. My husband's years on the farm have been underestimated. As we gave the succession plan of the year he's been on the farm, we presume that his parents have disputed these figures. As the relationship is now rocky, essentially they want to know how to get proof of service to make sure that you know, they can maintain, you know, an equitable agreement. So please ask. We'll cover these things along the way, and there'll be question time at the end. But please, as we go along, in the question box, ask questions along the way. And yes, there's a couple of people saying you are actually muted. Oopsie. Oh, I don't know how to get rid of that. Oh. Yeah. You are actually muted, because if we had everyone speaking, there would be a lot of background noise. So we take questions through the question box, and if we have time at the end, we will be able to unmute people and have a bit of a conversation. We'll see how we go. So we're not providing financial advice, and this goes for our 2 fabulous experts we have involved in today's webinar as well. And we really encourage you to obtain independent professional advice before making major financial decisions, and hope that this conversation and some of the resources that we can provide can empower you with some tools and the confidence to engage and get really great value when you do seek advice along the way. So we're able to provide this series of workshops and webinars for free, thanks to our generous partners. So we've worked with Rabobank, and we'll hear from Kim Lee today, who is a succession planner with Rabobank. And we've worked with Rabobank for a number of years and really value that partnership. We also have received the Financial Literacy Australia grant, which is helping us roll these programs out regionally. And we work with the FPA, so the Financial Planning Association of Australia, which is a great website to go and find advisors who are sort of registered with their industry body. Hairstyle and Industry Super Fund, the Tax Office, which, believe it or not, are generating some really great resources, and their website is much more user-friendly than it even was a few years ago. So there's some really great tools and videos on the ATO website. Understand Insurance is the Insurance Council of Australia's consumer education site to understand more about general insurance, and Credit Savvy, which shares a bit more about your credit reporting and some of the changes in that area. So we'll welcome our special guests. Thank you both very much. We have Kim Lee, who, as I said, is a succession planner with Rabobank, and Catherine Vincent, who is a lawyer who's been involved in our workshops in South Australia. Both these women, I'll actually leave for them to introduce themselves in more detail, but both bring huge professionalism and expertise and have a wealth of experience in this area. So we're really fortunate to have their time today. So thank you both, and perhaps I'll throw to you, Catherine, to introduce yourself, and then to you, Kim, to introduce yourself, and then we'll run through your slides first, Kim.
Okay, so I'm Catherine. I obviously don't want to spend too much time talking about myself because we've got a lot to get through, but I do have a passion for working with rural families, and I'm thrilled with Zoe's commitment to helping rural women in particular with their financial and succession planning, because it is a huge topic in regional areas. Basically, anyone who lives in a rural area will know what I mean. At the supermarket or down at the pub, there's always people talking about the latest grievances on the family farm, and I do my utmost to help, but I've certainly come across many or probably all of the pitfalls that come with poor succession planning, or even when there's been really good succession planning, there's been an aggrieved family member who's wished to strike a claim and create, to muddy the waters. Anyway, I'm here to hopefully help you work your way through some of those issues today.
That's great. Thanks, Catherine. Kim?
Hi. I work as a succession facilitator for Rabobank and have done for the last 14 years. And my function has basically been to facilitate family meetings, facilitate meetings where families make decisions around a range of things. It might be about working together, roles and responsibilities. It might be about agreements around transfer of assets. It might be contracts for use of resources, any number of things. It's a very complex and diverse field, what people think of as succession. I'm a partner in a family business in Central West New South Wales and have been since 1986. And we've helped around 500 families with their individual successions and helped groups of farming families with knowledge awareness over the last 15 years.
Great. So let's get into it, because as you both said, we've got an enormous amount to cover. Kim, do you want to talk us through some of the, I suppose, key things, especially I see, about opening communication and managing needs and expectations?
Yeah, so I think one of the very, very most important things in farm succession, and this is something that people don't spend enough time on, is having an understanding of their own needs and their own expectations, and clarifying them and describing them and communicating them. I think once everyone in a family knows that, you've got some decision criteria with which to work. So a lot of the disputes in family succession arise because, parents won't hand control over to the younger generation. So the discussion that hasn't been held is the discussion around careers and decision making and around roles and around control and around responsibility. And it's often the case, and it's often not stated, but it's just pervasive, that the older generation love the job that they're doing and they don't want to pass on control, and really it's their right to do so, but they may string the younger generation along with, the carrot of one day it'll all be yours, or one day you'll get some control, but it never actually happens. So for a large number of farming families, if they are very honest about holding on to the older generation, were a lot more honest about the importance of holding on to control, then there may be fewer of the younger generation that become disappointed further down the track. So having that honest conversation about your expectations about inheritance, your expectations around your career, your expectations around what the farm means to everybody is really important.
Mm-hmm.
And I think 80% of any succession plan should be spent clarifying this. And discussing it and rediscussing it, and just making it clear so that everyone does have an understanding of what, where everyone is going. It's just not about the business. It is about individuals' expectations.
So how, Kim, obviously it's easier to get an idea of our own needs and expectations. How do we, this for others column is blank. How do we, start that conversation, or start to understand other people's, or you're probably going to cover that in opening the conversation?
Yeah, so I think that is about communication. It is about not going into any formal or informal communication process. And let's face it, most of us actually go into these communication processes informally, when the stress is high, our blood's up and it's in our stomach and not in our head, and we informally say, this is what I need, rather than providing the time and the space and the tentative questioning around what other people need. I think that's a key. It's not rocket science. It is about trying to work those things out. So it is about asking very open questions, not why or what, or, but ask people how did they see their life? How has it been for them? What are their plans for the farm? And then continually drilling down to just have some idea of the landscape in which they're making their decisions, and the landscape and the history that has shaped what their expectations are going forward. So understanding differences is a significant area, and there are, generational differences in farming families, and those generational differences are to some extent getting wider as older farmers are retiring later, so we're having two generations on the farm, often for much longer periods now. And that also is around risk, different appetites for risk often between the younger and older generation. And, the older generation's often seen droughts, they've seen price fluctuations, they've tried things, and, the younger generation don't know anything. So there's that difference in perspective that comes, and often that becomes clearer if you ask the questions around history and how was it for you and why did you make those decisions. Gender, women in agriculture, it's a very different landscape to what it was in the last generation. The new generation of farming women are more highly educated than the last generation, and often more highly educated than their partners. So you've got women that are actually wanting to take major roles in decision making and are well equipped to do so. The cultural differences I refer to there are really the differences in, power and money and inheritance, I suppose, if you have it in those three categories. So, say in my family, everything was always going to be equal. The family I married into, inheritance was always the expectation it's going to be equal. But in many farming families, there is the idea that the eldest child receives more, the farming child receives more, and that's a cultural difference. And in some families, there's a cultural expectation that you don't talk about your business outside. In some families, it is, let's talk about it and let's ask, other people what they do. So culture around communication as well. Position in the family, if you've been the eldest and taken on responsibility and the youngest and maybe haven't had to take on responsibility, your perspective on roles and responsibility might be very different. And positions is really about, the disputes and perspectives that arise because people come home at different times. You may have an older child that's come home and worked for 10 years, things were tough, and the next child or sibling comes back and things are a bit easier and they may not have to work so hard, and there is, a position of probably disgruntledness that the older sibling might feel because the younger one gets it easier. There's also experience that the older one might have and therefore dominate the younger one. So there's all different sorts of, differences that arise for basically those 5 reasons.
Yeah, great.
So this diagram really looks at why or where the conflict arises. And we have the family overlap with the ownership and the business. And where all those circles intersect, we usually have fairly grey areas. So if you look at basically the family and the business intersection, these grey areas are, okay, so if I was not a family member and I walked into this business, what would my job description be? I would have to fulfil certain requirements to do that. If I walked into this business and, I got the job, there'd be terms and conditions of employment that they would employ me under. In family businesses, on farms especially, there is none of this formality around, setting terms and conditions, setting conditions around, what education levels you might need, what levels of experience you might need. You just, often fall into the job, or you've always expected you'll fall in there. So you've never had the discussion around what your roles and responsibilities or terms and conditions of employment might be. And when one family member steps in, it usually creates, the circumstances under which another family member may not be able to come in or may not be able to come in under the same circumstances. So conversations need to be held around that. With the overlap between ownership and family, it's about Catherine's area of inheritance, but family members working in the business, often because they're paid under market value, because there's expectations that they will inherit more in the end. It's not discussed, it's not made clear how that ownership would happen, how equity is earned. So it's a grey area. I think I'm earning ownership, but possibly there's no formal agreement around that. With farming, the business and ownership overlap is almost complete in that not many people work in family businesses from a family perspective that don't have some, future stakeholder in that business. So it's not really necessary to go into that in any depth, but it does involve things like, in this business, as owners, what do we expect as our rate of return? Do we reinvest it? Do we pay off debt? Do we all invest off farm so we can grow our own individual wealth or whatever? So, there's a lot within those three circles, and the overlaps and the grey areas that aren't discussed or documented create the issues.
That's good food for thought, and weaves in that question that was sent through about, the emotional aspects, because that often comes from that family management rather than, a business that you might have just commercially bought and walked in and, as you say, have everything clearly documented, roles, responsibilities, etc.
Yeah, and the reality is for farming families, the farm has a huge emotional value. People give up income to work on farms, and I mean that you can prove that, you know, statistically that's what they do. Sometimes it's good, sometimes it's bad, but the reason people ride that through is because they love it and they're attached to the land. And one of the basic problems that arise is that quite often farmers buy land as their retirement strategy. So I haven't seen many farmers sell land as part of their retirement strategy. So retirement funding often, or you know, in a large number of cases, in the majority of cases, comes from the farm. So farmers don't sell land; they just keep acquiring it, it seems.
Mm.
Okay, so financial and career security. This is, you know, about different needs, and this is the areas that require discussion and again documentation. But it is about making sure for both the established generation and the generation coming home what housing there is, what it's going to look like, who's responsible for improving it, is it going to be on farm or off farm, what's the ownership going to look like, what if someone dies, what happens to that housing, what if land's transferred, who can live in the houses on that land, all those sorts. There's a lot of stuff that sits in there with housing which is specific to family farms. Where's the income going to come from? Is it going to be for the younger generation a wage, profit share? Is it going to be share farming? You know, is it going to be market based? Are they going to be bonuses? Is there going to be equity, you know, recorded over time? For the older generation, do they have to come cap in hand? Do they write formal contracts for leases or you know, loans if they transfer assets across? There is strong desire in agricultural people for independence, you know, both the younger and the older generation, so they're not necessarily answerable to each other for income. And it's also extremely important that no matter what the older generation do, they quarantine sufficient assets to make sure that they're financially secure in the long run. So, you know, what does that involve? Does it involve a house in town? Does it involve, you know, land that they get rent from? What is that? There's a lot of stories out there where the farm's handed over and the older generation are left without any money. And for the new generation, you know, all of this, we need to actually talk about it in terms of inheritance and what off-farm children receive relative to on-farm children.
A lot of food for thought there. The two meeting agendas in one slide, isn't it?
There is, yeah. Now I'll just go through this quickly because I'm sure with 10,000 Girl you go through a lot of this stuff, but financial literacy and the numbers that count are really important for both generations to have some idea around. So you need financial transparency. I think that's the most important thing. So that's around what are the assets and liabilities, how has this business performed over time, look at the variability so you have some idea of where the risk sits, and then make sure that as a family you prioritise where the profits are going to go. Is it about growth? Is it about debt repayment? Is it about development of the business, or is it about spending to have some fun? That's a really important conversation to have on an annual basis. You know, 30 years down the track after it's all gone into expanding the farm and no one's talked about, you know, buying property off farm for mum and dad, it creates problems.
Great. So feel free, any questions that that you have along the way, feel free to jot them down as we go along, and we can weave that into the conversation.
So, I mean, I've covered some of this. I think we can go through that slide. I've covered off on, you know, the importance of, I suppose, roles. One of the really important things that I have learnt over time, though, in terms of this roles issue, is that if you set up formal communication, that is weekly, fortnightly, monthly meetings, if you get good at the weekly ones, you can move them into fortnightly ones, into monthly ones. Once you commit to doing formal meetings for, you know, an hour where you discuss strategies, you discuss operating issues, you discuss the finances, you discuss what's happening next week, the role that the change of roles between the younger and older generation happens automatically. It's where you don't have any formal communication that the roles become very separate and conflict arises.
That's a good point, and I think that there is a lot of discussion at our workshops and questions as well, Kim, about, you know, how do you start them? I've been banging on about, you know, the importance of family meetings. Do you have any tips to share about how to actually start and maintain those sort of formal meetings? Because those questions come up, I know, all the time.
Yeah, I think you have to couch it in terms of what's in it for everybody to you know, start this process of having meetings, and what's the risk if you don't? Because really, the risk if you don't is huge, you know. And it's the having a family meeting. It's like, you know, going on a fitness program. You know, when you first start, you hate it. You actually hate it. You think, oh God, how can I keep doing this? And, you know, every day you get a little bit better and a little bit better until finally you reach a point where, you know, you go for a run or you go to the gym, and it doesn't create any, you know, tension in your head. The same thing with family meeting. It's like starting to get fit. It's not going to be easy. So you don't give up because it's not easy. You keep reviewing the process. You look at, you know, so we've run a meeting, it went for 2 hours, no one could speak because mum talked all the time or whatever. You find ways, like you pass the speaking stick around so that everyone that holds the speaking stick, they can do it for 2 minutes, and they've got to pass it around so that people can't talk over the top of each other. So you get a way that everyone's views are held. You have a set agenda, and you know, if anyone's interested in getting hold of an agenda that I've worked on with a number of people over time that works, you know, you've got a session for detailing gripes, detailing good things that happen, talking about, you know, information that you need, talking about decisions that are being made. I can send that through, but it is about the risk that you don't do it is that further down the track we're going to be in a situation where there's going to be resentment. You know, we're not offering our family and this business the best chance that it can possibly have. And who would go into any business without doing their best, trying their best, and giving it the best opportunity they could possibly give?
Yeah, that's great. And I know that I've got a few young farming friends. I know my cousins who are running the family farm that I grew up on, and even my husband and I, who are not on in a farm business, but in another business, we're in sort of business groups with some like minds. So helping to open the communication and the planning as well, that extends a little bit beyond family, and there's a really nice knowledge sharing thing. And I know that there's a lot of those sort of planning groups springing up in different formats, aren't there?
Yeah, I mean, I think through organisations like land care or benchmarking groups or, you know, resource consulting services, there's any number of groups out there. I think what is important is that both generations attend any of these, I suppose, information forums or decision-making forums, so that they're listening and hearing the same things together. So we actually run a thing called Foundations of Farm Succession workshops, where we pull in both generations and we just normalise all these issues so that, you know, mum and dad and the kids on the farm can hear what other farming families are doing and find that, you know, it's normal that these things are hard, but it's important that you do have good communication structures and commit to them and review them.
There's a couple of great questions coming through. One I might wait till we hear from Catherine. It's about wills. But one is more of a comment that I'll just read aloud, and it reiterates what you just said, Kim. Is part of our challenge actually recognising we're running a business, not just a farm. Running a business naturally makes you think more formally. So that's a nice way to think about it. Thank you for sharing that.
Yeah, so I mean, I suppose these are points that I have to some extent spoken about, but I think early communication gives everyone the best chance of success. So, you know, people say, when should you start having these conversations? There's no right time. Early is important. If you haven't started early, start having them now. But just remember, one of the issues is that if that push comes from daughter-in-laws, it's much harder than if it actually comes from the generation above. So the culture actually should be led by the older generation, and the younger generation have to convince them that it's in their interests to have this communication. It's going to be the best thing for them, not the younger generation going and saying, this is what we need. You know, it's about proving to the older generation that this, you know, communication, this decision making, this discussion around succession is in the best interest of you, mum and dad. A lot of people won't face those hard questions, but, you know, if you start just detailing the risks of not putting them on the table, it's hard to mount a case to say that you shouldn't go through the pain to do it. Sometimes people say, okay, well, maybe if we do it with the accountant, or maybe we do it with a friend of mum and dad's, you know, to open the doors, it might be a way. Someone that they trust, it might be a way of doing it. And there's no doubt, you know, the more people you have in the room when you discuss these things, the better. But just make sure that whoever you do have in the room is working in the best interests of the family, not necessarily of individuals within that family. And finally, I've said practicing. You know, don't give up on that. Practice does make perfect within a business situation. And I must say, I just will go on and say, one of the difficult things is, you know, probably around 5% of farming families have formal meetings. The 5% that do run the best businesses. And I think that is very, very compelling evidence that, you know, this does give you the best chance of success. Just as much as any information you learn on spraying or animal husbandry or whatever.
A lot of information and a few really great questions. Someone said, you are so correct. Mum and Dad should have agreed to a wage as soon as the boys left school rather than having to look back now after 20 years. So, I mean, we can only learn from hindsight, can't we? So, I'll just read out a bit of a specific question about wills, and then we'll throw to you, Catherine, to talk through some of the legal bits and pieces, and then we'll have a minute or so for some questions. So someone said, Mum and Dad are looking at finalising wills and want to split farm and off-farm assets equally between 3 sons. Can you suggest a way to value a child's share in the farm when you have mum and dad owning the farm and 2 brothers leaving school in year 10 to work on the farm and 1 brother leaving the farm after school? No wages have ever been paid. Both brothers lived at home till being married, and spouses contributed financially to anything the farm didn't provide. So obviously we can't give specific advice about specific situations, but I'm sure both Kim and Catherine can draw from that what they commonly see and share some perspectives. So thank you very much, Kim, for your wisdom, and we look forward to hearing from you again in a moment, and we'll throw to you, Catherine.
Okay. Gosh, that last question, it's like the typical scenario when people come in, that they they come in with a cobbled together run of questions, and often they don't actually even know who owns, what asset in the farm or how the farm's structured, and it's been done by their accountant, often a long time ago, and they're not even sure where the deeds all are and what's going on. In relation to starting off here, obviously just want to make it clear too that the laws can differ between the various states in Australia, and I'm obviously practicing in South Australia, and I just want to make that clear that please don't seek to hang your hat on my advice. Obviously I want it to be helpful, but it will be very general in nature, so you should definitely seek your own advice before making any legal decision. And once you have sought advice, or once you've made a plan, and whether it is as a result of these family meetings that Kim has advocated so well for. One thing I just wanted to add to that too, when you are having these family meetings, especially in the initial stages, it is fantastic if you can have a neutral third party there, like Kim, to lead the discussion. I think that's also a great way of keeping everyone on their best behaviour and keeping everyone on track and on task. Once you've made that plan and you've want to seek your own advice and go to your own lawyer, obviously you need to consider who that is that you wish to see, and word of mouth or someone who practices in this area obviously is crucial. I think having someone who's had experience in the rural areas is a definite benefit because of these complicated family situations, and the family farm being the big engine that it is, the big business that it is. Once you've approached someone, it is a good idea to bring in what you can about your family situation, about the business, because whatever the advice the lawyer is going to give you is going to be based on the assets, how they're held, who owns them, whether it is owned by a family trust, the farm, or there can be various arms to those trusts, like the actual business itself may be run by its own service trust, and then the land's held in the land trust. All of this is for asset protection purposes, and I'll try and get to that when I'm speaking about trust later in my paper. But in determining how the property is held, also some people know that they own it with their husband, but they don't know if they hold it as a joint tenancy or whether they hold it as a tenancy in common, and there is quite a big difference in terms of succession planning or estate planning as to how that's dealt with. And that can be determined by way of obviously property searches through the Lands Titles Office or whatever the office is called in your state. Bring in your current will or any previous or other testamentary dispositions. This often helps provide a background to the historical intent or sentiment in the family, and also previous wills. If you have received an inheritance, it's of just good background information for the lawyer to work out the history of the wishes, the testamentary wishes in the family. Bring with you obviously an open mind. It can be quite overwhelming coming into a lawyer and just being hit up with all the various questions the lawyer will ask you, trying to get a feel for your asset situation and what you actually, the outcome you wish to achieve from your meeting and your ultimate succession plan. So be prepared to think outside the square, I guess, and have questions asked that you might not have anticipated. Bring a support person if you wish. Anyway, we'll skip to the next slide, I think. Thanks, Zoe. Oh, so yeah, with once you have worked out what you wish to do. Can I just skip to the next one again? I'll go to the will first, then I'll go back to enduring power of attorney. I've got it the other way around on my pages here. No, can you go back? Is there one that talks about wills? Where'd that go? You haven't got it.
Oh. That did have this weird cross thing to it when I received it from you. So we might just...
Oh, really? Oh, whoops. Oh, well, it's just a very basic slide that talks about your will, which is obviously asset control beyond the grave to some extent, but it's a crucial part of your succession plan. None of us know when we're going to die, obviously, and I've just got a few brief pointers here that I want to talk about, considerations for your will, and ideally you would have had a bit of a think about this before you come in to see your lawyer. Are you happy for me to talk about it without the slide, Kim? Or
yeah.
Oh, sorry, Kim. I meant sorry. Yeah, yeah, Kim. Yeah. So
then through some of the notes. So just speak to some of your principles and ideas for that, and we can send through any notes people want.
Yeah, it's just a basic checklist of considerations to be thinking about when you're giving instructions about your will. One of the most important things is who you're going to have as your executor, which is basically your legal personal representative, the person you want to take care of your affairs on an ongoing basis once you have died. Now, obviously, it is a huge role. Most people would appoint their spouse if they have one, because it is an intimate role as well to some extent. This person needs to firstly dispose of your bodily remains and then sort of pay out all of your debts, whatever they may be at the time of your death, and then distribute your assets in accordance with your wishes. But in determining your asset pool, they will need to go through your personal papers and affairs and just try and work out exactly what it was that comprised your estate. So someone will basically get to know you on a very personal and intimate level after you've died. So whilst most people would initially appoint their spouse, they'd also need to have a backup executor in case your spouse either dies with you or in case they have predeceased you. And that person you appoint should be someone that you trust implicitly, and also someone who is going to be on the front foot and proactive in terms of carrying out your wishes. I mean, some executors are just amazing. They're just really proactive and eager to get the job done and make sure they've chased every bunny down the hole and turned over every stone in terms of making sure they carry out your wishes. And that's the sort of person that you really want to appoint, get the job done quickly. And they're also the person that they're going to have to stand up and take the brunt of any person who challenges your estate. So they also need to, have some good legs to stand on in terms of facing up to any potential challenges to your estate. And that's also where we're kind of going with these farm succession plans. The tighter you draft the document, or and this applies to any sort of legal document, the tighter you can get it done, whether it's the trust deed or the will or the enduring power of the advance care directives, the less chance you will have of someone trying to challenge and challenge your estate and basically try and unravel your wishes. So that's critical. With your will, anything that's owned by the family trust will not fall into your estate. Neither will joint assets unless you're both dead. These are various things that we need to take into account. People come in here and want to talk about who they're going to leave the farm to, and then we find out that the farm's actually owned by a family trust and they have got no real powers, therefore, to give it away to whoever they please. They can give the control of the trust away through their will, potentially, but they cannot give the actual land away. They also need to think about whether they want to make provision for grandchildren, any special bequests they wish to make for a particular child, or any property that's been inherited through their family they may wish to leave directly to their blood, like their children, their blood relatives, rather than to their spouse, in case they die young and their spouse remarries and their estate that they've inherited from their parents might end up going down through the second family, so to speak. We need to think about the family wipeout if all of the husband, wife and children all die together, what's going to happen then to the estate, whether it's going to simply fall into the intestacy provisions where there's no will, which means that their parents might end up with it. This could be disastrous for the parents' pension, or whether they wish to basically nominate their siblings. Or it's good to have, I call it the wipeout clause, and have provisions for what happens when everyone goes in the same horrific accident or whatever. Otherwise, a will fail and it will be deemed an intestacy, and that would be disastrous after all of your estate planning to end up in that situation, potentially. People also some people like to make directions as to how their bodily remains to be dealt with, whether they want to be cremated or buried, and some of those directions can be legally binding on their executor. Okay. Oh, good, you found the slide. Excellent. Now, that'll hopefully do for will. We've got 15 minutes, haven't we? So we keep moving along. Please, next slide. Thank you. So that's all very well once you're dead and gone, but if you're still alive, but somehow you're incapacitated and unable to make decisions for yourself legally or financially, this is when you will need to appoint an attorney to basically stand in your shoes and be you for the purposes of making those decisions. Again, this needs to be someone that you trust implicitly, because they have got very broad sweeping powers. They can literally be you legally and sell property and make big decisions for you on your behalf, because you are either in a coma or somehow you might have become demented, or there's some way where you cannot actually make those decisions for yourself. The only things that an attorney cannot do for you legally or financially is, one, rewrite your will, and secondly, they cannot sign bank guarantees Sure, that's right, Kim, isn't it? Otherwise, they can pretty much do anything else that you can do, legally or financially. They can go to court for you, they can sue people, they can do all sorts of things. So do not make the appointment lightly, and the person you appoint would, again, most likely be your spouse or loved one or a child, someone that's very closely connected to you, and or otherwise a very trusted friend. If you don't have an attorney and you become incapacitated, then it would be up to the guardianship board to appoint someone on your behalf, or the public trustee to run your affairs for you, if in the absence of anyone who's willing to act voluntarily in that role. You can make the appointment to more than one person, and they can either hold the appointment jointly, where they have to make decisions jointly, both of them signing off on them, or it can be joint and several, which means either one or both can make that decision. Excuse me. And again, the appointment can be an immediate one, which is often the case with an elderly person who lacks mobility, can't get out and about easily. They will often appoint maybe a child or someone to immediately become their attorney, even though they are still of sound mind. There are risks involved, and many of you in the country areas may have heard of disastrous situations where, for example, a child has run off as the mum and dad's attorney and sold property or transferred property to themselves. All sorts of things can go on. So you need to do not make these appointments lightly. Make sure you get expert advice before you do anything binding in this way. If you do change your mind, if something you want to appoint someone else, that's all very well, but you'd need to specifically revoke the former appointment, and you need to serve that person with that document. So that could be often a bit awkward, but if you sort of maybe you want to change a child, you have got one child on as your attorney and you're worried that maybe they've developed a bit of a gambling habit or something, and you think, oh gosh, that's not a great idea, and want to change your mind, you specifically need to serve that child or person with a notice saying you are now formally revoked as my attorney. And that's all you need to do. You don't need to say they've been replaced, but then the replacement attorney won't really take legal effect until such time as you've revoked the former one. Thanks, Zoe. Next slide. The advanced care directives. This has taken place now of what was formerly known, or certainly in South Australia, as enduring power of guardianship. These are the end-of-life decisions or decisions that someone can make on your behalf once you, again, have lost capacity to make decisions for yourself, either because you're unconscious or demented or in a terminal illness where you are unable to communicate for any reason. Now, you can at any time in your life before that happens, set out in a large document your wishes, as to how you wish to be treated. If you are in a terminal illness, or whether if you're going to be going into a nursing home, if you have any specific requests, you can set them all out, and those wishes aren't necessarily binding on the person that you appoint to make those decisions for you, but the decisions that will be binding are the end-of-life type decisions, things that may result in your death. For example, you may choose not to be resuscitated, where the expected outcome of whatever you're suffering is poor. If you have a heart attack and you're already in a state that you don't deem worthy of remaining alive, and you may not wish to be resuscitated or have treatment to try and revive you from that defibrillator from the heart attack. Anything like that, or whether you're in a terminal illness and you're suffering a lot of pain and you want to receive as much morphine as possible, even if the morphine might kill you. Any decisions like that, any directions like that are legally binding on the person that you have appointed to make those decisions for you. So again, there's a lot of, I think the more detail the better that you put into your advanced care directive documents. I would suggest that you do it in consultation with a lawyer or someone who's got a good grasp of the English language that can specifically write down what your wishes are. The person that you are appointing to carry through those wishes for you must read and sign for all of those decisions before you then sign the appointment. So it's a very much involved process now, where the person who's taking on who's potentially going to be taking on those directions from you has to be very well familiar with them and understand what their legal responsibility is before the document is declared legally valid. I do encourage people to put detail in. A lot of people think, oh no, my daughter will know what I want. She knows me really well. I just think that's all very well, but it's probably quite unfair on the daughter, who may then be faced with some pretty horrendous decisions to make for you down the track. And it's much of great comfort to her to know what your specific wishes or directions were, or at the time that you were able to make them for yourself. It gives her comfort when she ultimately has to instruct your carers at the time as to what to do. Okay, next one. Thanks, Zoe. Okay, trust. Excuse me a sec. A trust is a powerful tool, especially in like a farming succession plan, mostly for asset protection. People use trust, and also for tax minimalisation. So accountants love them, and they're basically the farmland can be owned by a trust, which means that whilst you have legal ownership to the title of the farm, if you're the trustee of that trust, the actual beneficial ownership of the land is not in you, it's in the beneficiaries of that trust. So it basically removes the ownership from you, so that, for example, if you fall into debt or owe someone money, they can sue you, but they can't get at that big asset, which is the farm. So it protects the farm from creditors, and it also, for succession purposes, when you die, it'll protect the farm from anyone who's not in that class of beneficiaries, for example, a former wife or people like that who want to try and claim against your estate won't be able to get at the farm when it's owned in a trust, because it doesn't legally vest in you the actual ownership of the land. There are different types of trusts. I know that Zoe specifically wanted me to talk about family trusts, which are probably most useful in a farming situation. Also superannuation trusts I know are used often in family farming for like investment properties and whatever. There are very strict rules about superannuation trusts though, and that they have to pass the sole purpose test, and that any property acquired in a superannuation trust isn't able, all the value accumulates to that trust until such time as you either retire or die. So there's no immediate access to the trust property if you are still working and not of retirement age, and certainly if you're still alive. The family trusts are simply set up through your lawyer or even potentially through your accountant. You need to appoint a trustee who has, various duties to do everything in good faith in the best interest of the family farm or whatever the trust asset is, and it's often and for the betterment of the family, basically. And that farm can stay in that family trust through the generations. It doesn't have to, whenever someone dies, it doesn't have to go through probate or be anything. It just can stay as an asset of that family trust. I'm happy to, I'm conscious of time. I'm happy to, I don't know if anyone really, how much people know about the duties of trustees and rights of beneficiaries. I'm happy to talk about it, but I also wonder if you want me to throw back to you, Zoe, for questions.
Yeah, well, maybe if people have some specific questions. I mean, Kim and Catherine, you have shared a huge wealth of information, so thank you very, very much. And thank you also again to the partners that make this, able to do this. If anyone's got any more questions, please send them in. We've got 5 minutes, and yeah, would love to cover what areas you're most interested in. Otherwise, while we wait for those questions to come through, maybe Kim and Catherine, we ask you, what's one sort of maybe common mistake that you see often that can be alleviated through an action, or one sort of tip or pearl of wisdom that you think might benefit people? And then I'm sure that there'll be a couple of questions that will come through.
Yeah, I think. Oh, sorry, Kim. You have to go.
That's okay. I was just going to say, and this is in line, I suppose, with the third question in that list. I think one of the most important things to work through is when you do come home, to the family business, or when you do invite a child to come home, if you're one of the older, generation, make sure that you are very clear about what equity this child is earning in the business, what they're worth to the business over and beyond what they're getting paid. If they're being paid a market-based rate of pay, then that's not necessarily an issue. But in reality, a family member coming back to the family business is worth a lot more than a farmhand. They're usually far more accountable, far more responsible. They're usually, much more passionate about what they're doing. They'll stay until a job's done. There's all that's there that it makes them worth a lot more. So you need to have a conversation about what is it that I'm worth, and what value do I add, and what am I contributing? Because this business might be growing while that person's at home as well. So you need to have a discussion about, are you going to be left more in the will? How is that going to be, or is it going to be documented that a certain amount's owed, or is there going to be an asset that's bought in your name, which outlines, or which is in recognition of the input that you've made. So, it just depends on how ownership's held, the flexibility that you do have in doing all these sorts of things. But one thing that families I've seen do that works quite well is you make an agreement about what you're worth, and you document it, and it might be documented, and it might become a loan that the business owes that person. If that person leaves, it might become a loan that's used to buy a property. This is all theoretical, like cash isn't changing hands, but you need the big picture, high level look at what it is that what the contributions are worth, and then you avoid the problems around trying to calculate things when things have gone bad. So I can, yeah.
Yeah, that's really valuable, and it comes back to starting the conversation and starting some sort of formalized documentation and planning as early as possible, doesn't it?
Yeah. One thing I think I'd like to add to Kim's comments, which it's a perfect lead into what I think is a good take-home message as well, is that you can plan as thoroughly as possible, and I think planning in the way that Kim's suggesting is an excellent way to do it, because generally there is a notion of equity or fairness in law. Despite what has been agreed, if you don't take the model on that Kim is recommending, and if you do it some other way, like a court can intervene and overturn whatever the family has agreed if it deems it to be unfair. For example, in South Australia a few years ago, there's a very famous farming case where a father over the years had made all these assurances to his son, who'd worked tirelessly on the farm for all the years, that on the basis that he would get the farm one day, as is so often the case, just on his word around the kitchen table. That exact evidence was used to ultimately have the court find in favour of the son that the father, in saying all those things and making those promises over the years, effectively held the farm in constructive trust or untrust for his son, and his farm had basically an equitable interest in the farm that his father was trying to deny him when it came to the will. So, equity will prevail if the law is a just beast at the end of the day. It tries to be anyway.
Yeah, I agree. And one of the problems in succession planning is we do hear all these horror stories out there, but my experience has been that, it is just usually. What if things end up in the legal sphere, the outcomes usually are fairly just.
Equity will prevail. That's what the court tries to do anyway. That's the purpose of it.
Yeah.
But obviously it has to be an aggrieved party. Like someone, has to bring it to the attention of the court. It's not like the court's not doesn't police these situations. You have to bring the matter to the court's attention, or nothing will happen. You know what I mean? Like, you do have to activate the process.
There's one, thank you, because that's extremely relevant and useful and practical. There's one quite practical question that's just come through. If you're taking minutes of a farm meeting, is the legal term minutes, or is there a legal reason why it should be called record of meeting instead, please?
Oh, excellent. I think it would be very effective. Would carry similar weight. I would call it minutes just because that's the terminology, but I think both it means the same thing. And if you're following an agenda, it's nice to minute it correctly, and then you've got a nice flow chart of who's going to action this and that and whatever, come and report back to coming into the next meeting. I think it's a nice formal procedure that has worked for time immemorial. So there's any sort of written record of the meeting, anything in writing. Lawyers love things in writing. It's great to have a written record. This one, I just quickly touch on this question that someone sent in earlier about the farm and the lack of records back further than 97. Now, whilst I don't want to be bound by whatever I'm about to say, there are, certainly in our state, there are rules about trustees of having to keep financial records of tax returns and all that. And if the beneficiaries want to look at them, they are to produce them. The other thing, though, if those records have really been destroyed, or there's no way of clawing back, that the written word, there may be people in the community who could give affidavit evidence as to that son working on the farm 30 years ago, or there could be old photographs, or there could be that sort of circumstantial evidence, or other such way of proving that he worked there longer than 20 years ago, or whatever the year was. And the other thing in that question, I noticed that they're presuming that there's been the parents are disputing the figures. It may be the succession planner that misheard, or there may have been a typo or a mistake. I mean, I'd certainly clear that up first before I would assume that the parents are doctoring the years, but maybe that is the case. But you can sort of overcome these things with third parties, independent third parties who are prepared to give evidence that they know for a fact that this son was working well before the parents say he was, because of X, Y, and Z, and there may be photographs, or there's maybe some other way of proving it other than tax records, is what I'm trying to say.
Great. So we've probably got, we're running on time, but if any other burning questions, please use the question box in the control panel. And thank you all very much for your commentary and participation. And a huge thanks to you, Kim, and you, Catherine, for sharing your expertise and experience with us. It's really valuable, and I'm sure that people will take a number of things from this session, whether you're listening live or if you're listening to the recording. And good luck with everyone's plans, and may the communication be open and proactive.
Thanks a lot, Zoe, and congratulations to you too for your commitment to rural women of Australia. I think it's really fantastic, and I support you wholeheartedly. So good for you, and thank you, Kim. I really enjoyed listening to your session too. That was excellent.
Yeah, ditto. Thank you to you both. It's a great opportunity. I hope you all out there got something out of it. But I must say it's a huge topic, and an hour is only just scratching the surface.
Absolutely. Yep. Okay.
There's a lot of thank yous, and that this was relevant and helpful and good, and there's a lot of thank yous coming through. So thanks, Kim and Catherine. I'll wrap up the recording now. Thank you all very much for joining us, and we look forward to supporting you with other information into the future.
Okay, great.
Thank you.
Thanks, everybody.